Good morning, everybody. I'm Frank Pennachio. I want to share with you how I even arrived here today, or what got me to this stage. The Chief Revenue Officer at ReSource Pro, Patrick Armstrong, has been a both professional and personal friend of mine for over 25 years. And he called me up a number of months ago and he said, Frank, do you think you can actually present on your self-funded rants something that could be structured in a way that it was an opportunity for agents? And I said, I think I can do that. So that's what brought me here today. And what I want to do is share a really big idea with you today. You'll decide at the end of this 30-minute presentation whether it works for you and whether it's a big idea or not. But let's jump in. I sincerely believe the greatest opportunity in the entire insurance landscape right now is in the self-funded healthcare space. Over property and casualty, over professional liability, everything really takes a back seat to this, but it's not likely for the reasons you may think. I believe it's coming from a very different space than what you typically hear out on the streets. Yes, there's massive growth in this space. How many of you hear agents talking about self-funding and level funding and all this kind of your mama funding and all that kind of stuff? It's the buzz, because and who can blame them? They're getting their faces eaten off every day at renewal time because the rates have gone up and the costs have gone up and they want something different to talk about. So, and they've got people that will help them talk about something different, and that's what we're going to take apart a little bit today. Now, this is an extremely scary statistic from the National Association of Insurance Commissioners. Take a look at those numbers. 40% of employers from 3 to 99 employees are leaving self-funding and, are leaving fully insured and going to self-funding. That is frightening. Why is it frightening? Well, we'll talk about that in the next 27 minutes or so. It scares me. I actually talked to the gentleman at the NAIC who was quoted with this, who was attributed with this quote, and he said they're meeting about it at that level because they are worried as well. And it's not just because of the roads, ACA, there's a whole bunch of other reasons. Most employers under 100 employees have no idea what they're buying when they go into self-funding. And they don't have the resources, intellectual capital to deal with all the complexity, which we'll jump into. Now, here's the typical pitch. This is what agents like to talk about. And I don't blame them. I don't blame them. They've been trained typically by carriers and stop-loss captive organizations on how to sell this stuff. They say, look, you can have customization. You don't have to go with the state mandates, and you can customize things and reduce your costs. You're going to save money. Everybody loves the save money pitch. You're supposed to get data transparency. Yeah, unless, of course, they have their clients sign a TPA agreement that doesn't give them any access to their data, which happens all the time. You can avoid the state mandates and the taxes, and of course, those insurance companies are making all that money. You can capture their profits with self-funding. We're going to make this a secondary pitch. We got a bigger pitch. We want to talk about our bigger presentation. Now, here's the biggest issue that drives me crazy. And you notice I called it misinformation, because lies, you have to actually know you're misrepresenting something. And I don't think people are out there lying. I think they're saying what they've been told to say. But here's the big piece of misinformation. And it's a quote. I redacted the source. The person who said it's not here to defend themselves, so I don't think it's fair to give them attribution. So let's just leave them anonymous. But this is said frequently. Because of stop-loss insurance, self-funding is no riskier than a fully insured health plan provided by an insurance company. Folks, that is just unequivocally, that is metaphysically wrong. It's not an opinion. I mean, even the Self-Insurance Association of America, which I've attended their conferences a few times, they will tell you, and they're the world's largest, this is what I like to say, we're the world's largest association supporting self-insurance, that it's riskier, carries a lot more liabilities than fully insured. And why is that? Let's talk about why that is, because there's an extraordinary distinction between self-insurance and insurance, or like they say down here in the South, welcome to the South, I live right down the road, insurance. So it's a big difference. On the fully insured side, the employees get a plan. If it's covered under the plan, the carrier pays. If it's not, the carrier doesn't, the employer's in the clear. No problem there. Everything's good. But this is what's really different. With a self-funded plan, and I'll tell you momentarily how this happens, if the claim is covered under the plan, the employer is responsible to pay that claim irrespective of whether or not the stop-loss policy reimburses the employer. And I've never seen a stop-loss policy that has just one sentence. Because quite directly, if they wanted to tighten this up, stop-loss policies will have one sentence. If it's covered under the plan, we'll reimburse it according to the deductibles. Doesn't happen that way. Doesn't happen that way at all. Now, I get annoyed when I go pay money to go to a conference myself and this kind of stuff shows up on the screen. Here's the typical worst case scenario slide that every business owner has probably seen. It starts with you're going to pay your administrative costs, okay? You're going to have to pay your stop-loss premiums, specific and aggregate stop-loss premiums, usually both. We're going to have an actuarial expected claim amount that you're going to fund, and then there's a 25% risk corridor, and that's your worst case scenario. Again, I don't think it's a lie, but it's absolutely metaphysically incorrect. Because what they're not going to tell you is that there's additional costs like denied stop-loss claims, which could be in the millions. Typically not, but could be. There's also additional excessive fees. Fees are not covered under the stop-loss. Now you may think, well, I know I have to pay my TPA costs. It goes way beyond that. I'll talk about that momentarily. ERISA violations and penalties. Managing a self-funded plan. Look, fully insured still comes under ERISA. By the way, it had its 50th birthday last year. And nobody really talked about it. ERISA's 50 years old, especially the property and casualty folks, which that's for the topic at 1:45 this afternoon. But the ERISA violations are coming faster and more furious by the day. If you're reading the trades right now, you're seeing that we're seeing far more lawsuits coming from the health plan space. It started over on the 401k and pension side a number of years ago, and it's moved over here. That's more your worst case scenario. It's not, hey, if you don't have any losses, you're going to get money back, that whole level funded pitch, or you're going to reduce your costs. Plus, the other thing that doesn't get talked about enough is ERISA, federal law, Employee Retirement Income Security Act of 1974, violations of ERISA can pierce the corporate veil and attach personal assets. How many 25 employee plumbers buying these level funded plans are aware that now their personal assets are at risk? Not many. They've just been told, hey, things go well, you're going to do good. If things go bad, here's your worst case scenario. They don't talk about this. Now, fiduciary liability and responsibility is a really big thing. Again, because every fiduciary, and it's not just the CEO, the CFO, or the HR person. Oftentimes, HR people are not aware they're a fiduciary and are not aware their personal assets are at risk. Anybody who touches or manages the plan, including the support team and the benefits committee at the employer, they're a fiduciary. Their personal assets are on the line. They're not getting the training typically. They're not even aware of the complexity of the challenges that they're facing. And it is complex. It doesn't mean it's bad. Look, I'm not anti-self-funding. I'm anti-proper transparency. I'm anti-not communicating effectively. I'm anti, risk-reward being laid out properly. These folks are being told there's no greater risk, so you might as well do this. And that's just wrong. So let's look at this complexity a little bit without going too deep. We have all these different contracts. It starts with the health plan itself. That's what goes to the employee. Here's your health benefits. And then there's a stop-loss policy that has to align with the plan. And I'll give you some examples of how sometimes that doesn't happen. Then we have the claims administration agreement, which is in a TPA relationship, is a completely different company typically, who may never have seen the stop-loss policy and may have a completely different arrangement around how they're going to manage claims that the stop-loss carrier is not in alignment with. We're not done yet. It's even more complex. I think somebody was talking about eligibility earlier today. You could change the eligibility with the employee handbook. Sometimes the employee handbook eligibility requirements, or not requirements as much as eligible to be on the plan, are different than what's in the health plan, and many times way different than what the stop-loss will pay on. Someone would be eligible for benefits. Stop-loss says, not under our plan, because we only pay when they're out on COBRA and FMLA, not approved leave. If you'll pardon me just a moment. Thank you. And we haven't even forgotten about the network agreement, which could tie into the TPA agreement, which could tie into the stop loss. Who's coordinating this stuff? I'll share a couple of stories with you. But first, clients should never sign a contract as is. Never. Never should sign a contract as is. Brokers should not be putting contracts down in front of them, whether it be TPA or ASO arrangements, and say, sign here. A negotiation must occur. I was working with an agent last year, and he asked me to come on a call with a TPA that he was vetting. I said, well, let me see their claims administration contract. And I identified 10 or 15 things that I had some concerns about. The response from the TPA representative, oh, Frank, that's just lawyer stuff. My question to my client was, Dan, where's your lawyer? They got one hanging your client out to dry at about 15 different places here. Clients should never sign a contract as is. Now here's a quick little story. Agency in the Midwest, I love them. They're a fabulous agency. They were just getting hammered by the competition on an MGA self-funded health plan program. You ever have that happen? Oh, we're just getting killed with this program. We got to go represent this program. They asked me if I would do the due diligence. Happy to do so. Called them up. I said, we have a mutual client. It's your client. Or actually, it's not your client. It's my client who's looking to become your client. Could you please, they've asked me to do the due diligence before they join you. Could you please send me a copy of the plan, the stop loss policy, and the claims administration agreement? I didn't even get to the network contract. Just leave that out. They said, well, we can't do that. I said, why not? He said, we only sell the stop loss. We never even see the plan or the claims administration agreement. All we do is sell the stop loss. Are they coordinating? Who's coordinating? If their stop loss is not in alignment with the plan, that's a big problem. That's a really big problem. I'll give you some examples shortly. There's a real hotshot stop loss group captive program out there, and I have no criticisms of the model, but their approved TPA list had exorbitant excessive fees, crazy fees. Now, you may or may not be aware that excessive fees is a big issue right now, and litigation is arising if an employer is paying fees that are excessive and according to ERISA not prudent, wouldn't be prudent, not prudent. I'm the only one that knows who George H.W. Bush was, but that's okay. That it can be a real problem. My client and agent said, well, why don't you talk to him? Called him up, got with the guy that approves the TPAs, and I said, these fees are not prudent, they're outrageous. I said, the agent's gonna get in trouble and your clients are gonna get in trouble, and the answer was, not my problem, the employer signs the contracts. And I have no fiduciary responsibility. ERISA only puts, as the law stands today, and they're looking at this, the employer on the hook for the fiduciary losses. They don't even care, not my problem. I don't have the risk. Excuse me. So let's talk about how stop loss claims can be denied. Because the employer's on the hook if it's covered under the plan and the stop loss says we're not paying it according to our terms and conditions and limitations of our contract. First thing, the eligibility issue. Here we got a situation where the employee handbook says if you're on approved leave, you're eligible to be on the plan. What does the stop loss say? You have to be on FMLA or COBRA. I've even seen some that even just say FMLA. You switch over to COBRA after 12 weeks, it's silent, scary, really scary. But we'll get to that. This one's scary. The plan says to the employee, we're not gonna pay if you have a medical crisis or injury as a result of a felony. Written into the plan. You commit a felony, most common example is probably a DUI with bodily injury. That's likely a felony. We're not going to pay for your injuries. Stop loss, though, will frequently say, we're not going to pay if it's an illegal act, which means a misdemeanor, which means it's covered under the plan, but not under the stop loss. Usual and customary payments. What does that really mean? What does it mean to the network contract? What does it mean to the TPA? What does it mean to the stop loss? Typically, I don't even know. To be determined later, based on the profitability of the account. Now, oftentimes you'll hear people say, well, we mirrored the plan with the stop loss. Well, I don't know what they mean by that, because when I read the plan and the stop loss, there's holes big enough to drive a Mack truck through. So be careful when you hear, oh, don't worry, we mirror. Well, send them to me and let me see your wonderful mirroring arrangement. Didn't work. Fees. Let's talk about fees, because they're not covered under the stop loss. Now, again, you may think, well, that's just TPA fees. Everybody expects to pay TPA fees, maybe some cost containment fees. The big buzz is always point solutions. Some of these carriers, or some of these folks out there are pitching 10, 15, 20 different point solutions to help you cover costs. All of them come with big fees, but here's the biggest one, subrogation. So in the health plan and the stop loss, the stop loss, not the plan, in the stop loss it says that they're allowed to subrogate. Sure, negligent third party runs into your employee, hurts them real bad. The negligent third party, this probably isn't happening in Florida, they have insurance. And let's say they have $1 million liability, auto liability coverage, and they really hurt this employee, and there's $1 million recovery and subrogation. You know what the fees are on that? $300,000, 30% of the recovery. Not covered by stop loss. The employer has to go into their pocket so that the stop loss carrier could get their money back. And I learned how this was such a big deal when I went to SIA once again. I was like I was hunting around for an ERISA attorney to represent employers. Tough to find, because this is what they want. And certainly they're not going to represent employers where they can represent a TPA, get all their subrogation business, and get 30% of the collections to be paid out of pocket by the employer. All this cost containment stuff, reference-based pricing, I'm not going to go down that rabbit hole right now, but be very, very careful when somebody says we have a reference-based pricing program. Oftentimes the fees are not only imprudent, violating ERISA, but it ends up making the cost far greater than the network agreement. Not going to go there, just be aware. And also, percentage of savings. Bill review on percentage of savings. According to the NAIC, National Association of Insurance Commissioners, if states pass their model law, it would be illegal. We're going to give you 35% of the savings that we found. Many times, the TPA paid the claim wrong. They fix their own claim and charge you a fee to fix their mistake. I'm not making this up. I'm not that creative. Now let's talk about these ERISA violations, of which most employers, especially smaller employers, don't even know they have. Failure to act in the best interest of the plan. Now that sounds easy, but how many people out there, their agents, their golfing buddy? How many don't have a documented process to vet their golfing buddy against everybody else in the community? Sometimes it just takes a written process and a documented process. Provide the required disclosures. If you come to the P&C thing later, we're going to talk about what health agents have to do right now. We're talking to it about what the P&C people need to be aware of is, all compensation has to be disclosed now, both direct and indirect. Not to mention all the disclosures that employees are supposed to get on a timely basis. Summary plan descriptions, all that kind of stuff. Well, the compensation disclosures, a couple of weeks ago with the Masters going on, I saw this ranting and raving on LinkedIn about all these brokers that were the Masters and how they're going to now give all the business to the carrier because they got to go to the Masters. You know what? I'd target those brokers' business because I can almost assure you they're not disclosing the value of the trip to the Masters under indirect compensation. Don't complain. Compete. Don't hope agents go to the Masters every year and then go get their business, because I can almost assure you they're not disclosing that. Other ERISA violations. Monitor service providers. The fiduciary responsibility is on the employer, not the TPA messing up the claims or charging exorbitant fees or hiding things or in alignment with the pharmacy benefit management company in cahoots with them. And it's on the employer. This is serious. This is big. Oftentimes, there's not even a contractual arrangement to allow the employer to monitor the service providers. Because guess who writes the contract? The service provider. And guess who's not negotiating that contract? Virtually everybody in the smaller group space. When I say smaller groups, I generally believe No one should be self-funded unless they have 300 to 500 employee lives. Non-employee lives. There's no actuarial credibility. You don't have the resources in-house typically, and selling this stuff to smaller employers is like selling a financial instrument of mass destruction. Excessive and undisclosed fees were mentioned already. Now, cybersecurity is typically a P&C thing until 2021, when the Department of Labor, which even shocked other people in the government, came out and said, oh, no, au contraire, mon frère. That's all I know in French. That's it. They said, because of the big risk, and especially the 401k space with how many trillions of dollars are in there, now it's a fiduciary responsibility to go through, not only you go through all these cybersecurity risk mitigation, but your carriers, your TPAs, your PBMs, all of them have to validate to you that they've done the same thing. Is that happening out there? It's not happening out there. The P&C people don't even know about it, and the benefits people aren't implementing it. It also goes to HIPAA, other data privacy issues, which get much bigger because now there's underwriting, individual underwriting in the self-funded space that you don't have in the under 50 or under 100 employee, depending on what state you're in, and fully insured. Gag clause attestation, every December 31st now, people have to go into a government portal and attest that there's no gag clauses, meaning you're not allowed to know how much we're paying the medical providers, and on and on. You have to attest that none of that is in any of the contracts that you're engaged with, many of which you haven't even seen. So you have to test the government. We don't have any gag clauses. Who's doing that? Who's checking to see? What are people doing? They're just saying they don't and crossing their fingers. And then, of course, mental health parity has been a big thing. They keep adding to the legislation. It's very problematic, and it's hard to stay on top of what's required. Now, what happens? Well, you can have civil and criminal penalties for violating ERISA. This is serious. This law is a serious law. Personal liability for the fiduciaries, as I mentioned. You want to get involved with folks, or you want to get their attention, simply ask the question, has anybody ever shared with you that your personal assets are at risk based on the way in which you manage your employee benefit plans, especially group health? But we have the best attorneys in the state, and they've set up LLCs and corporations and 10 ways to Sunday. We're protected. All of that gets pierced like a hot knife going through butter if it's ERISA, a breach of ERISA. Plan participants are starting to sue. You may have seen the JP Morgan lawsuit that happened just a couple of weeks ago. The participants are suing because the pharmacy benefit management program is 300% more costly than GoodRx. You know, I'm not one of these coupon guys, but I like to get over on the man at the CVS with my GoodRx card. Yes! $130 script for $29.99. Yes, I got over on the man. And then, of course, the DOL, Department of Labor, audits, class action suits. You're reading about this now. Now, be very wary of what we call recency bias. Many times agents will say to me, but Frank, the stuff you're talking about, I've never seen it happen. Well, what's your sample size? How many clients do you have? Some of these folks are, you know, in skinny jeans and bro haircuts and you know, they haven't been around long enough to see stuff happen. Be wary of, if it's in the contract and the risk is there, at least make the employer aware or make it go away. One of the two. There is a risk reward. Again, I'm not opposed to self-funding. I'm opposed to the way it's being sold. I'm opposed to the way it's being mismanaged. And I'm opposed that more employers have everything they've built, possibly for generations, at risk unknowingly. If they know it and they assume it, that's their job. They don't know it. They don't know it. So, what does all this mean? Well, I ask you this question. How many employers out there, either on self-funded or level-funded, which, by the way, level-funded is self-funding. They try to change the words around. They say, well, it's really like fully insured on a self-funded chassis. What the hell does that mean? That is just nonsense. Nonsense. It's self-funding. How many employers out there are on these things, especially as you saw earlier, 40% of employers under 100 employees are buying this? They have no idea what they're buying. No idea. And with all due respect, the agents have not been informed on what they're selling. In many respects, it's not their fault. As they say here in the South, bless their hearts. They just don't know. Who's going to teach them? The carriers that don't want all this stuff to be known? An agent one time said, well, Frank, the fully insured plan is costlier for the same level funded plan with the same benefits. Well, why do you think that is? They've shifted more risk to the employer. That's what the whole principle of insurance is all about. So I ask you that question. I ask you to think, how do you think they'll respond when you help them or your producers help them become aware of these risks? Everything I have is at risk. And then you start to take them through where they could be on the hook for denied stop-loss claims, excessive fees, go on down the list. Sunlight is the greatest disinfectant. Let the employer decide. That's Judge Brandeis, Supreme Court Justice, firmly believe that. Tell the story, let them decide. Let them decide. And then Patrick knows I'm a big fan of Daniel Kahneman. Unfortunately, he passed last year. Nobel Prize winner for economics, and he was a psychologist. What did he teach everybody? People fear losses far more than they value gains. And they will change to you when we help them see they're at a greater risk of loss instead of come with us and you're gonna get this, and you're gonna get this, and we got these point solutions, and you're gonna get this, and you're gonna get this. People will move when they find out the amount of risk they've unknowingly assumed. So what are the next steps? Yeah, this is the typical pitch, but make that secondary. You can talk about that stuff, but make it secondary. That's not the primary reason that people should be having this conversation. We have to talk about the personal asset risks, the complexity, and would you be surprised to learn this, this, and this, and this. I think the best prospects out there are, well, really anybody on self-funding, but it's public record if they have over 100 employees as to who they are, where they are, when they renew, who their agent is. That goes on the 5500 form. So if you want to target 100 and up, you know where every single company is, you know who their CFO is, or whoever signed the 5500 form, and what the agent's making on fees, and I can promise you, more times than not, virtually all the time, they won't have a clue as to what risks they've assumed. And try this out. Go in and say, can you give me a copy of your stop-loss policy, your plan, and your claims administration contract? Good luck. They can't find it. They may have never gotten it. How can you manage that stuff if you've never seen the contracts? You're likely going to find significant risks of financial loss unknown to employer. Is that a value proposition for your agency? You could lose it all. You could lose it all. I haven't seen that happen. Yeah. I live in a community that hasn't seen 2 hurricanes hit ever in the past 100 years. 2 weeks apart. Never seen that happen. Water was up to here. Frank, never seen water that high. Yeah, until you do. Until you do. So become the selected broker in agency before you even go to the market by having these conversations up front. And I can assure you, once you get access and have this conversation and lead people through this discovery, I am out of time, and it worked out okay. So in the event you want to chat, I know I'm standing between you and lunch. Always tough to be between lunch and a presentation, but if you want to chat, I'll be hanging around. Thank you very much.